Hello, this is Professor Keith Ross from the John Jay College of Criminal Justice. This is a series of ongoing lectures for my classes. This lecture is going to be from my criminal investigation class, and this is going to be Chapter 2, Enhancing Patrol's Function to Criminal Investigations. I think what we really sort of need to think about is what is an investigation? And investigations, I think, really sort of do three things. One, when you're investigating something, you make an observation. You look at the big picture. And then you start inquiries. You start questioning things within that big picture, and do they fit into your investigation or not? The decision that you make of things that do fit and do not fit in your investigation is a determination. So really, when we're talking about investigations, we make observations, we question what we see in those observations, and by answering those questions, we make determinations about our observations. So when we're talking about investigations, usually we are sort of chided by the media as to, well, only detectives conduct investigations. Only detectives are investigators. And really, nothing could be further from the truth. Patrol, uniformed police officers conduct investigations, and detectives conduct investigations. The thing is, they do their investigations differently, and they sort of both have a different frame of mind when conducting those investigations. So patrol's role in solving crimes, the average beat cop, the average officer that's driving in an RMP, radio motor patrol vehicle, or marked RMP, all police functions emanate from patrol. And without patrol being the backbone of police departments, there is no structure to the police. So patrol conducts investigations. Again, different than what detectives do. The patrol division must be included in the daily effort to solve crimes that have already happened. So if an offense has been committed, let's say we have what's called a quote unquote robbery pattern, meaning two or more robberies that have taken place in a specific area. Well, not only are detectives going to be investigating this, but what does patrol do? Well, patrol basically responds to service calls, responds to 911 calls. So they're out and about, they're looking. You might find, maybe I have a picture of this robbery suspect. Maybe the detectives haven't found this robbery suspect, but patrol, maybe even benignly, go out to lunch to pick up lunch. And who do they see in the restaurant? The picture on the want ad that's in the precinct. So patrol can then affect the arrest because they've conducted an investigation. They've seen the picture. That picture shows that there's probable cause, and they affect that arrest. The very nature of the patrol function is to be reactionary, meaning something has happened and then patrol responds or reacts to it, meaning that they wait for a call of service. In the NYPD, those calls for service are called radio runs. They respond, conduct, and underline this preliminary investigations. And what do? Well, they're going to take a report because, as any good police officer, any rank knows, if it's not on paper, it did not happen. Patrol's role in solving crimes. The key to solving many violent crimes is maintaining and securing crime scenes, detaining witnesses, obtaining descriptions and direction, method of flight. So with any investigation, and really anyone who's conducting an investigation, whether it is patrol, whether it is a detective, they do ask similar questions. And honestly, it doesn't matter the severity of the job. If patrol is investigating a noise complaint, or if a detective is investigating a homicide or a murder scene, we're still going to ask the same questions. Those questions can be remembered as NEOTWY, Neotwy. Every successful investigation answers most, if not all, of those questions. Now, you're probably thinking to yourself, that's a weird word. It's not even in the dictionary. And you're correct, because it's sort of an acronym, but it's an acronym of the last letters of the questions that you want to ask. So, any investigator, patrol, detective, or otherwise, when they're conducting an investigation, they're going to ask these questions, these NIATWI questions. The N is going to stand for when. When did this happen? The E will stand for where did this happen? Did it only happen at one place? Did the crime scene, or did the offense, or did the incident happen at one place and then get continued somewhere else? Did it end somewhere else from when it was continued? These are questions that need to be asked. The O, pretty important. Who? Who did it? We want to know who the perpetrator of this offense is. We also want to know, who did it happen to? And another good question is, who else might have seen it, and do they have a connection either to the perpetrator or the victim or another witness? The T, I want to know what happened. Tell me everything about that incident. The W, how did it happen? Sort of connected to that T. So I want to know what happened and how did it happen? Was a cell phone snatched out of my hand? Was I punched? Was I put at gunpoint and said, "Give me your phone or I'm going to kill you"? I want to know how that robbery took place. And more often than not, patrol will not answer this question. They can, but they don't have to. But this is really more the purview of what detectives do. What they're going to want to find out is the why did it happen. When we're talking about the why, there are two other ways to sort of think about what the why is. The why is the motive for the offense, or you can also call it the modus operandi. They all mean the same thing. The motive, the modus operandi, answers the question, why was the offense committed? Detectives rely on this as well as observations patrol officers make while responding to and upon their arrival at the scene. Now, again, patrol conducts investigations. So if they're responding to a radio run and someone meets them there, patrol is probably going to ask those NIATWI questions. Hi, how are you? Can you tell me what happened? What's your name? When did this happen? Where did this happen? Anyone else see it? These are basic questions that have to be answered for any sort of investigation. The next slide, the RAND Criminal Investigative Study. This was conducted in 1973. RAND is a big corporation that does a lot of studies. They did some studies in the 2000s regarding stop and frisk. So same research institute. In 1973, the first study of its kind to determine actually what detectives do and how do they sort of do it. It had a ripple effect throughout many departments, and here is what was found. Here's just some statistics just to know. 30% of all arrests were made at the crime scene. So 3 out of 10 at the crime scene, the perpetrator is there and arrest is effected. 7 out of 10 offenses, at least in 1973, further investigation had to be conducted, meaning that an offense was committed, the perpetrator fled the scene, and at some later date, that perpetrator was apprehended. 50% of all perpetrators arrested were identified by a victim witness at the crime scene. The remaining 20% of these index crimes, and what we're talking about are major felonies, murder and manslaughter, rape, robbery, burglaries, grand larceny of automobiles, arsons, possibly kidnapping could be thrown in there, really burglary as well, major violent felonies. The remaining 20% of these index crimes were left to the detectives, but patrol still arrested many of them, again, at a later date, as well as information supplied by the public in the form of tips. Crime Stoppers in New York, and this is sort of a mode that has been sort of transplanted to other jurisdictions as well. Definitely the major police departments have some sort of Crime Stoppers kind of phone line, meaning Someone sees something, they'll call Crime Stoppers. And why are they calling Crime Stoppers? Because Crime Stoppers will offer a reward for credible information that leads to an arrest. Criminal investigations can be broken down into two major parts. Definitely a testable concept here. There are only two types of investigations that take place: the preliminary investigation, meaning the very first investigation, and the follow up investigation. That is any investigation that takes place after the preliminary investigation. The preliminary investigation is a brief probing for facts and to identify evidence. So we're going to ask those NIOTWI questions. I want to know, when did it happen? Where did it happen? Who did it happen to? Who did it? Who might have seen it? What happened? How did it happen? Might not figure out why it happened, but I could get that information depending on maybe if I find some sort of probative connection between the perpetrator and the victim. In some cases, it will include the arrest of the perpetrator if no crime was committed or it was a civil matter, meaning it's not a wrong against society, it's a wrong against another person. Things like vehicular accidents, things like contract disputes. And just remember, if we're talking criminal offenses, the legal burden of proof necessary to establish guilt beyond a reasonable doubt. In civil trials, in civil matters, the legal burden of proof to establish guilt, preponderance of the evidence, that 51%. If it was a civil matter, the officer will take the report and make referrals. Let's say that there is a vehicular accident. One person says it's the other person's fault. The other person says it was that person's fault. Police are not going to make a determination at the scene. A civil court judge will make a determination as to who has more fault than the others, if it even comes to that. We'll close out the case and file that report with the station house clerk. Preliminary investigations, patrol officers respond and begin that preliminary investigation at the scene. The first responsibility of the responding officer, the first responsibility of any police, is to protect life. So if a person is injured, we are going to render primary medical aid if possible. Even if the perpetrator is climbing out of a window while we enter into that scene, if the perpetrator is in that house and is running away outside of a window and I have an injured victim, what I'm going to do is I'm going to treat the victim first. I'm not going to go after that perpetrator. Now, that might sort of sound counterintuitive to you, but let's think about this in the real world. If I see this perpetrator, I can probably give a description. While I'm rendering aid, I have a radio. I can go over the radio, be on the lookout for male white, approximately 5'7", blah, 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 heading west on Main Street, something to that effect, wearing red shirt, green pants, blue sneakers, whatever the case may be. Even though I'm rendering aid to an injured victim, I can transmit this information and other police officers can start, quote unquote, canvassing or looking for this perpetrator. What should they do if this happens? Again, render aid. We protect life first. A thorough preliminary investigation and a prompt notification to an investigator, i.e., a detective squad, PDS, Precinct Detective Squad, are the keys to solving and clearing cases. Patrol's actions can make or break the case, and stressing the importance of this at roll call by supervisors, by a sergeant lieutenant, possibly a captain or an inspector, can make all the difference in the world. Patrol officers are partners with detectives in solving crimes. They might work in separate bureaus, but they have to work together. We have to play nice in the sandbox. Every effort should be made to collaborate when possible. So patrols should have an open line of communication with detectives. Detectives should have an open line of communication with patrol officers. And more often than not, that usually does take place because usually what happens, those detectives were once patrol officers, more likely than not, probably in that same command. So we've all made sort of these relationships and these friendships, so we understand each other. Listen, I'm looking for this guy. All right, you know what? I'm going to be doing a directed patrol. I'll keep a lookout. Something to that effect. What we don't want patrol to do, what detectives don't want patrol to do. We don't, if we have established a crime scene, let's say we have a dead person, apparently shot, apparently dead, and we see a gun maybe 3 feet away from that victim, that DOA, dead on arrival. We don't want everybody in the crime scene. We don't want them handling the dead body. We don't want them handling the firearm. We don't want them handling any spent cartridges. The less people that are in a crime scene, the less chance of that crime scene getting contaminated and or tainted. One other thing about crime scenes, when in doubt, make the crime scene as big as possible. It's always easier to shrink a crime scene than it is to establish a very small crime scene and then have to widen or broaden that crime scene. Because once you start widening that crime scene, well, now you have the chance of tainted evidence, and now we have to do elimination samples to show that a person was not the perpetrator at the crime scene, that they were there afterwards. So let's say a police officer goes into that crime scene, and even though they know that they shouldn't have touched the firearm, they pick up that firearm. As an investigator, as a detective, I'm going to have to take that police officer's prints and include that in my case, because I have to show that I'm excluding the fingerprints that are going to be found on that firearm because this officer wrongly picked up the firearm. Leave family members access to the crime scene. Well, if we don't want a million hands of police officers in that crime scene, we definitely don't want family members at that crime scene. We don't want them removing evidence. If we have a dead body, we want to make sure that we get pictures of that body and how we encountered it when we first entered that crime scene or first established that crime scene. So, we don't want people moving the body, laying on the body. The weird things can happen out on the street. Forget to obtain pedigree information. Full name, date of birth, apartment numbers, nicknames, street names, cell phones, email addresses, known associates, things like that. Even if you don't think it might be a piece of evidence right now, later on down the line, it could be a piece of evidence. So it's better to get more information and then start excluding that information. Well, this is what the patrol officer said. I didn't really need to know the email address, something to that effect. Again, never make the crime scene too small. When in doubt, make it as large as possible. It's so much easier to shrink than it is to expand. Think that this is the only crime scene. Where there is one, there could possibly be another. Maybe the perpetrator committed the same offense to a family member, or maybe another day, whatever the case may be. When in doubt, you always have to start keeping your mind open and thinking outside the box. Just because I'm looking at one crime scene does not discount the possibility that there might be another one. Patrol officers should not read Miranda warnings. Now, this might sound counterintuitive too, but what do patrol do? Well, they conduct preliminary investigations. When we start interrogating perpetrators that have been caught, we're more in the purview of what a follow-up investigation is. Now, when do Miranda warnings get triggered? Well, first, the person has to be in custody. What does custody mean? Custody means that the person is not free to leave. If a reasonable person would say that person was not free to leave, he or she is in custody. Now, a lot of times you see on TV, every time that a person gets arrested, you see patrol issuing Miranda warnings. That is not a reality. Miranda warnings only get triggered, one, when a person is in custody, plus interrogation, meaning you're asking questions about specific acts of criminality. So if I arrest a person and I ask them their name, their address, their date of birth, their cell phone number, known associates, I never have to read Miranda warnings. Now, if I start saying, Why'd you do it? And that person answers me, well, that question of why did you do it? What exactly am I asking? Well, I'm asking about specific acts of criminality. Now, if the person is arrested, this person is in my custody. If this perpetrator tells me everything, in a Huntley hearing, for those of you that remember the Law and Justice module, anything as soon as I said, why'd you do it without issuing Miranda, all of those statements will be considered to be inadmissible, which means I'm not going to be able to use it. So I might have had I might have had the right guy. I probably had the right guy, but he's going to be acquitted because I could not use his statements against him. Now, if I ask that pedigree information and then read Miranda and then say why you did it, and the person gives it up to me, all of that will be included. It will be admissible at trial. Forget to include secure entry and exit points into the crime scene. A lot of times when you see crime scenes, you'll see that black and yellow tape. Make sure that there is at least some place where investigators can enter and exit. Forget to secure the victim's clothing and other personal effects. Why? Because it could possibly be evidence. Response squared, this is talking about canvassing. What you usually want to do is you start when, and what is canvassing? Canvassing is basically conducting an investigation, gathering information, and usually I'm either canvassing for evidence, physical evidence, or I'm canvassing for witnesses, which would then be testimonial evidence. What we don't want patrol to do, forget to ask EMS what hospital they are transporting the injured person to. We want to know where that person is, because if patrol didn't talk to that injured person, maybe they were unconscious, there might come a time when they become conscious again. Someone's going to want to talk to them, and that's probably going to be a detective. Again, touching evidence unnecessarily. If I find a gun on a floor, there's really no reason for me to touch it. I know it's a gun. And I would rather leave it there and secure it, making sure no one touches it, and wait till a crime scene unit gets there so they can start photographing how everything was found first before we remove it and before we start testing that firearm in a ballistics lab. So we want to, again, take photos of the crime scene, want to take big photos of the whole crime scene and specifics. And a lot of times we're going to put a ruler on evidence so we can give that evidence some scale, so that when a detective has to testify at trial, that detective could say, well, that bullet casing or that cartridge casing was about an inch long. And how would that detective know? Because we're going to measure it. We're going to approximate that measure by putting a ruler next to that. We don't want police officers and or detectives making posts on social media about the great arrest that they did. Because if they do post that, guess what? That stuff becomes Rosario material, meaning that it's material that has to be given in, and it's material that the detectives have to include in their case. And the most important part is, this is material that has to be turned over to the defense attorney's side so that they can poke holes or impeach credibility. Take victims, witnesses, and perpetrators in the same car. In the NYPD, pretty big department. So if I'm transporting a victim to, let's say, a precinct, and I have a perpetrator that's arrested, that perpetrator is going to go in another vehicle. If I have independent witnesses, we're going to get yet another vehicle, and we're going to bring them all to the same spot, and we're going to keep them separated. Especially when we're talking about victims and witnesses, what we don't want is victims and witnesses to start talking to each other. Because I think I'm not sure if I've said this, but one of the things about the human mind that's sort of interesting, as soon as we observe something, we start forgetting it. So let's say something happened to me and I'm a victim. Well, I've observed it and now I start forgetting it. So I remember about 80% of it. Now, if I have a witness, let's say a family member, and we're being transported in the same vehicle, I could start talking to that witness, that family member, and saying, you know what, I don't remember this. My family member now says, oh, this is what happened. So now when I relay the information to an investigator, I'm going to give them 100% of a story. However, it's not 100% of my story, basically what happened now is that I'm giving them 80% of my story and then 20% of the story of those holes that were filled by my family member. That's not what investigators want, because that sort of sounds like collusion, actually. So we don't want that. If I have a victim and all they remember is 80%, that's the statement I want to record. You don't want to disturb computers, cell phones, and or other electronic devices. So if this is part of a crime scene, if this is part of an investigation, I don't want to touch it, and I definitely don't want to go into it until I've procured a search warrant. So, and this is sort of an interesting thing. If I get a search warrant to go into someone's residence, if it's not specifically stated on that search warrant and I find a computer, and I think that there is a reason that that computer is connected to the offense that I procured a search warrant for, I'm going to need a separate search warrant to go through that computer. Same thing with cell phones. If I get arrested, the police are going to take my cell phone and they're going to invoice it or voucher it as personal property. What the police cannot do is go into my cell phone and look at contacts, look at pictures, look at text messages without a search warrant. And I'll be quite honest with you, as a retired police officer, even if I had the consent of the perpetrator, I would still probably go get that search warrant, because it could be argued by the defense that even though I had the perpetrator arrested and the perpetrator, quote unquote, of sound mind, gave me consent to go through that cell phone, it could seem like it wasn't true consent because he was in custody or she was in custody. Let witnesses confer with each other, exactly what I had just said before, or forget to detain witnesses, because witnesses talk to other people, and if they're starting to forget stuff, maybe someone fills their head. So the 70% that they remembered, now they're getting another 30%. We want as valid statements as possible. Well, this was a short lesson, but I think there was some good information here. I wish you guys have a great day and take care. Bye.